our roundtable discussion, the last session for this day one of the LexTalk World Global Conference, which is on the topic of enhancing cross-border dispute resolution in the Commonwealth, exploring effective mechanisms for resolving legal disputes across jurisdictions. And to speak on this topic, I would like to welcome on stage Ms. Smita Chandrashekar, Director Legal at Harman International India Private Limited. Please have a huge round of applause, ladies and gentlemen. Next is Ms. Aastha Chawla, Director at American Arbitration Association, ICDR Asia CMC. Please have a huge round of applause for Ms. Aastha Chawla, ladies and gentlemen. Next is Mr. Balakrishna Gopalakrishnan, founder at BGK Law Associates, Advocates and Legal Services. Welcome again, sir. Unfortunately, Mr. Kanishk, Director Legal Uber India and South Asia, and Mr. Abdul Rahim Padinharis, Senior Legal Manager at Cars 24 Arabia, couldn't join us today. Further, Dr. G.V. Rao, Senior Advocate, Supreme Court of India, Vice President of the Indian Society of International Law, is on his way and would be joining us very soon. So I would request all the other people to start their the roundtable discussion. Thank you.
Thank you. So, good afternoon, everybody. I hope you're all refreshed after a chai break. Since the panel is like really small, we'll try and keep it as shorter and as crispier as possible, right? So, with that, let's kickstart the session. I'd like to request my co-panelists to give a real quick introduction about themselves, please.
Thank you, Smita. Thank you very much. I'm Aastha. I'm the Director Asia of American Arbitration Association, International Center for Dispute Resolution in Singapore. As a part of the institution, my duties involve case management from across Asia and also business development for the institution across Asia. I'm very happy to be here and on this panel. Thank you very much.
I think in the morning I have introduced myself, but I'll add some more things. I'm Balakrishna, and I run a law firm called BGK Law Associates. And formerly I was heading the law department of Axis Bank, and I was working with the RCIL also, Asset Reconstruction Company. And after that, you find somewhere here, a small emblem called CCAI. That's a Corporate Counsel Association of India. It's a gathering of in-house counsels, and I happen to be the founder president of that. And I'm also a guest lecturer in many of the law colleges, and I'm in the board of studies of some private universities with regard to law. That's it. Thank you.
Thank you so much. And I'm Smita, and I'm the legal director for Harman, and been around in the field for 2 decades now. Feel so old. Right. With that, let me just quickly start the actual session. So in terms of quick statistics, before I proceed, Mr. G.V. Rao is here, so welcome. Perfectly on time then. So this, I'm happy. That at least a senior person is here, and we will definitely be benefited by his words of wisdom, right? So with that, quick statistics in terms of numbers, I was just taking a look at the cases disposed of by SIAC and Hong Kong International Arbitration Center, and in the year 2023, there were at least about 300 plus cases which were actually settled by these arbitration centers, right? So that's that. And arbitration, mediation, conciliation, things like these, the whole dispute resolution mechanism, right? It's a pretty old concept, if I may say so, because WTO, World Trade Organization, in fact, started disposing of or hearing matters way back in the year 1995. And apparently till now again, out of the 600 odd cases which were filed before them, about 300 plus cases saw the light of the day, and it was like very wonderfully sorted, right? So dispute resolution mechanism, especially for cross-border disputes, has definitely gained momentum over a period of time, right? So with that, quick introduction. Aastha, I'd like to ask you the first question. So you are from a dispute resolution institution, right? So coming from this particular institution, what's the recent trend that you've actually noticed in the dispute resolution arena, especially in the APAC region, because you are based in Singapore, right? So that's the first part. Second part, are there any challenges that you have been noticing as an institution? If yes, what is it that your institution has actually done to kind of deal with those challenges? So I think this will be very important for the audience to understand from a practical perspective, since you are the institution, you're representing an institution. Over to you.
Thank you very much, Smita. Thank you for the very topical question that we are dealing with these days. And before I answer the question, I understand that you have mentioned the caseload of cases settled by SIAC and the Hong Kong Center, HKIC. I would also like to add on that AAA, American Arbitration Association, in 2024, starting from 1st of January, has resolved 95,719 cases. So it is just in first 1.5 months that we have resolved around 1 lakh cases. And since 1926, we have administered around 8 million cases. So that's the caseload that we have. However, having said that, Singapore, SIAC and HKIC, most of their caseload is international arbitrations. With AAA, we are both domestic and international institution. Our domestic caseload is very high. Around per year, we administer 500,000 cases. As far as our international caseload is concerned, which is held by ICDR, ICDR is another segment of AAA, which handles only international cases, and caseload for international cases is around 800 to 1,000 cases every year. So before, I just wanted to mention that and introduce probably our institution, probably the recognition it deserves, and probably justify my salary. So now coming to the questions that you've asked, recent trends. We all have read the recent judgment on Amazon versus Future Retail, where an emergency award was passed, and it was then taken to court, where the question of law was whether Indian law recognizes emergency awards or not, and whether such an emergency award is a final award or not, and can it be enforced in India or not. So these questions were addressed by the Supreme Court, and it was held that these emergency awards are an internationally recognized concept and must be enforced. This happened in 2022, later, end of 2022 and beginning of 2023, there were appeals as well. So, although emergency arbitration was introduced by American Arbitration Association back in 2006, however, the trend of emergency arbitration has become popular in Asian region only in the last 1 decade, and in India, it's still picking up. And thankfully, we have Amazon versus Future Retail, because of which now Indian parties are not hesitant, and even foreign parties are not hesitant in applying for an emergency award, and since they know that it can be now enforced in India, because an award is nothing unless it's enforced. So that is one recent trend that we are seeing in India. The other recent trend that also is very close to my heart is mediation. Mediation has been picking up. Singapore passed its mediation convention recently, and there are certain countries who have now ratified to the convention. But in our rules, in AAA-ICDR rules, earlier before 2021, the concept was when two parties have arbitration with ICDR, they can opt in for mediation. In case they want to mediate, they can write to ICDR that we want to mediate separately. Is it okay that we go ahead with mediation? And that was an opt-in clause. However, we amended our rules in 2021 to promote mediation, and now the parties have to opt out of mediation, which means that if the parties are going for an ICDR arbitration, it is presumed that they will go for mediation as well. Now this might come across that it is a tactic for delay. So to cater to that issue, what we did is that the arbitration and the mediation will go parallelly. The timelines of the arbitration will not stop because of the mediation, so that no party can use mediation as an excuse to delay a case. If both the parties agree that the arbitration timelines must be stopped, then we, of course, because arbitration is completely party-driven process, in that case, we stop the timelines of arbitration. But if there is a disagreement between parties whether the timelines should be stopped, the rules say that it will go on as per the timelines mentioned in the rules. Now, it has another impact apart from the delay and everything. It is the cost involved. Now the parties are usually, and especially from a in-house counsel's perspective, the most important thing that you would ask us is, why am I going through double the cost? So while the cases, if you, for example, and I'm not comparing institutions here, that's not something that I want to do, but when you file a case with SIAC, and if you want to mediate, SIAC will send your case to SIMC. So the arbitration case will go with SIAC, and the mediation case will go with SIMC, which are two different organizations. However, in our case, once you are filing an arbitration and you want to mediate as well, both arbitration and mediation will go under the same head, which is AAA-ICDR. However, the arbitrator and the mediator will be separate. Now the question in your mind would be, I'm still paying double the fee. I'm paying the arbitrator and the mediator as well. And there is an administrative fee as well for the institution to conduct these arbitrations and mediations. So I would like to emphasize that for a mediation, the administrative cost that AAA-ICDR charges is $75 per hour. That is negligible. When parties come with huge claims, they would not think about $75 per hour. And in our experience and having analyzed the caseload that we have received, what we have understood is that if parties are really serious to mediate, the average time taken would be somewhere between 10 to 15 hours to resolve a mediation case, to come to a settlement. So in that case, if 10 hours is taken, the administrative cost comes to $750, which is it's a very reasonable cost to come to a final conclusion of a large claim matter.
Plus you have quality.
Yes, definitely. It is process-driven, it is quality, there is trust, and if at all the mediator is not responding, you write to us that the mediator is not responding or the arbitrator is not responding, because sometimes counsels hesitate in reaching out to the arbitrator or mediator because they don't want to jeopardize their stand. They don't want to tick off the arbitrator. So they can reach out to us. It's our responsibility that the arbitrator is functioning in a timely fashion. and we will take care of it on your behalf so that the councils are not bothered with the process. And apart from this, there is definitely mediator's cost. I must mention that it is not just $750 that will be required. Mediators also need to be paid. So if your mediation and how it goes is resolved in 10 hours, the mediator's cost will also be not too much. So mediation is something that is picking up now in Asia, even in litigious jurisdiction as well. US is also considered very litigious jurisdiction, but still their mediation is now very progressive. And in fact, to give mediation a further push, all case managers of ICDR were given incentives if they can just get both the parties to mediate. And this actually portrays the ethos of an institution, that they are looking, their aim is to resolve the dispute. Their aim is not money making. It is resolution of the dispute. So that is another trend that is upcoming. Another thing is online case management system. Earlier, all case management was done manually. And courts were also, the filing was done manually thanks to COVID. Not thanks for COVID, but thanks to COVID that now we have e-filing system in courts. Similarly, with us, not just the filing can be done electronically, the whole entire case management is electronic. So your, all the documents that you are uploading in our case management system, they're absolutely secure. Data protection is provided, so all security is provided. So now, although AAA-ICDR has been using online case management system for a very long time, but now HKIC got their first online case management system, I believe 1 year back. ICC has said that they are working on it. They're working on it. They will get it out soon. SIAC will roll it out probably next year. So that is another trend that is upcoming. Now, the other part of your question was, what are the challenges that we are facing? As far as challenges are concerned, I would just talk about India. The biggest challenge is that despite there being brilliant institutions, most of the arbitrations are still going to ad hoc. Now, this is the biggest challenge that we have. In ad hoc arbitrations, though, the perception is that they're cheaper, but since it takes such a long time, eventually it becomes way more expensive than institutional arbitration. So that's one challenge that we are facing, converting ad hoc arbitrations to probably institution arbitrations. And I'm not saying that choose AAA-ICDR, I would want that, of course. But I'm saying the shift from ad hoc arbitration to institutional arbitration, whatever institution that may be, is the need of the hour, and we must proceed with that. Thank you very much.
Thank you so much, Aastha, for the detailed answer to the questions. I think the key takeaway, from an in-house counsel's perspective here is, one is definitely, the summary of it is privacy, right? Because as opposed to a traditional court system where everything is public, here it's done indoors. So there's absolute privacy. Second, I think in terms of the entire case management itself, like you rightly said, all the necessary, actions in terms of data protection, as well as, all the other aspects like, no tampering and all the protocols, are followed. I think that's the great part. And also, I think in terms of the whole mechanism itself, it's quicker and it's efficient, right? So that's what we want, end of the day. So I think it kind of ticks the boxes. With that, I'll quickly move on to Mr. G.V. Rao. Sir, thanks for coming over. I think you don't need any introduction, so I'll quickly, move on with your first question. So being a senior litigator, you spent I think, a lot of time on the field, right? So can you touch upon how ADR has actually evolved in India, and in what way has it impacted senior litigators like you? I think the audience will definitely love this question.
Thank you very much. Well, it's a right question for somebody like me. who's been there for more than three and a half decades in the legal arena. And most of my work, I started in the Supreme Court, at the then Attorney General's chamber, famous now, who argued the Ayodhya matter, Mr. K. Parasaran. And we've seen, the legal system and, the adversarial system transform, and the alternates come forward. And therefore, the Arbitration Act, it took a turn sometime in the 80s when, the Arbitration, Mediation and the Conciliation Act came into force. And gradually, for all commercial disputes, it was the go-to forum and the method. Earlier, arbitration used to take place by court appointing XYZ retired, by and large, retired judges who, depending upon the kind of matter, the kind of, stakes involved, or whether there would be a senior or a Supreme Court advocate, retired Supreme Court advocate, or a High Court advocate, depending upon whether it was, some property matter, or if it was a commercial dispute. So it would all be like ad hoc, courts would choose, and the court would appoint the arbitrator, and then, it could go on for a long time also. But by and by now, over the years, the alternative dispute resolution system has fallen into place, and it has become more and more sophisticated, more and more nuanced. And also due to the fact that India being a destination for, great foreign investment and great enterprises coming in and businesses. So likewise, the arbitration and mediation, etc., have the alternate dispute resolution mechanisms have increased. And by and large, senior counsels like me or anybody else, what everybody has sort of transformed themselves. Of course, some people just specialize in mediation and arbitration, etc. But some of us, we've sort of, transformed into being able to handle matters even before an arbitration, or try to, bring about a settlement. And you have to do that, because most of the time now, the arbitration, mechanism and the ecosystem has grown in such way that we have pre-litigation mediation. Now court sees there's a matter where it could be solved by going to a mediation center. It would say, why don't you just go to the mediation center and see if you can resolve it, and then we will continue if you have failed to do so. And the mediator has to give a report saying that, the mediation has failed. By and large, now mediation has also come. There's an act for mediation. Now, arbitration and mediation are somewhat slightly different. Arbitration is an informal method for resolving the dispute, essentially commercial disputes, by, not having the formal ways of going into court and hearings, etc. You could have a dedicated set of arbitration, or you could go to the International Center for Arbitration. And now all of these arbitration centers, one in Mumbai has come up, the Delhi arbitration center is there. There's one in the Gift City which is getting involved. So commercial arbitration is now evolving by institutional, what is called the institutional arbitration. Their disputes are lengthy. There are, a lot of documentation has to be gone into. Again, those centers also have retired judges by and large as arbitrators, but then there are some experts, lawyers also who act as arbitrators. So institutional arbitration and ad hoc arbitration, they are moving side by side, but for larger, for instance, the Hyderabad center is a world-class center. It's a world-class center like the SIAC and the other arbitration centers that you're talking about, the ICC in Paris, or the Stockholm, or the US, AAA like she was saying, or the Hong Kong, all of these, the infrastructure is matching. So international commercial arbitration, is more easily dealt with such a advanced and, well, worked out and well-designed system. It is our premier center in picking up work, and it's getting busier and busier by the day. Recently, the SIAC, which is the #1 arbitration center of the world, has signed an agreement with the Hyderabad International Arbitration Center that we have there. So that those things are evolved, getting developed by and by, and people like us, litigators, also go and appear in these places for arbitration matters, because at the end of the day, your knowledge of law is important. At the end of the day, you need to find methods by which you want to resolve the disputes for the clients and in a more relaxed atmosphere, by a dedicated forum. In a court hearing, you get a date here, and then it goes off to another 3-4 years. These things can go on for days and can be resolved during a particular time. So a lot of lawyers have just gone into becoming arbitration lawyers, exclusively dealing with arbitrations in these forums, and they're able to help. So it's something which we also have adapted ourselves, and we think that it is fruitful and it is very beneficial to the legal system and the people at large looking for remedies.
Thank you so much, sir. So I think next, Mr. BGK, I'd like to check with you, since you've been in the banking domain predominantly, right? So how is ADR, viewed in the banking arena? Because I think banks traditionally used to be reluctant, right? So probably things have changed. So I'd like to hear, your views on the banking sector in particular.
Yeah, I think before I begin, I have one thing is that, Aastha was saying about so many cases being settled, so thank God that it is not pertaining to mostly in India, because, it's a global scenario you are saying. Otherwise, me and Mr. Rao will be out of job, because I know. One thing is that, one or two questions, one or two issues we need to understand is that today arbitration is for real. That is not disputed anywhere. And, we have, as Mr. Rao said, that there is a global infrastructure in Hyderabad, in Mumbai, and, in Delhi, and, other places. But how many of us make use of that? We still are addicted to one thing, that we want ad hoc arbitration. Because, when a judge retires from the High Court, his sole aim is that I have to make up the entire money which I have not been able to make up during my judgeship, and therefore that comes only from arbitration. And we advocates are also responsible for that. We believe that, yes, arbitration is there, I have to name him. And one thing is, Senior Advocate Rao said, is that, Section 11 petitions are still pending. A lot of Section 11 petitions under the arbitration is still there. In Bombay High Court, at least, I appear for a lot of Section 11 petitions, and therefore, in Bombay High Court, in the afternoon, one judge, single judge, sits for that only. And the result is that when I name somebody as an arbitrator, and, definitely the answer comes no. And, then he names somebody when my answer will be no. And ultimately, we have to go for a Section 11 petition. That takes some time, because it takes at least, 1 month or 2 months to get somebody approved. And then he names somebody and he gives a time limit. And then one thing is that if it is a senior advocate or a retired judge, he says, the schedule fees is not applicable, and, you can fix it according to your whims and fancies. And after that 12 months period is over, and definitely it will not get over, because depending on the money and the amount involved, and it is extended. But solely by asking you get extended, because depending on the name of the arbitrator. But Commercial Courts Act says that before filing a suit in the commercial court, mediation is compulsory. But look at the reality of that mediation. That mediation is just a farce. You go there there some advocates will be sitting there. You go there and somebody may not come in the first time, and in the next time is given 1 month's time, and after 3 months, he says mediation failed. 3 months are gone. So either there is no mandatory requirement, mandatory, some kind of a sanction is not there if you don't appear to the mediation, then it becomes, Mediation Act has also been passed now, so Mediation Act is also being passed. So mandatory sanction should be there, and, like we say, commercial courts, you can't file your reply within more than 120 days. That has been reiterated by many high courts now. The latest being Kerala High Court said that, you cannot say that, so that has to be compulsorily there. And if you look at the RERA Act also says that, before the adjudicating authority takes up the matter, he asks you whether you want to go for mediation. Yes, mediation is one compulsory thing which you can go, but mediation may or may not happen because, people believe that if I mediate and if I write something, if it doesn't approve that, doesn't comply with that, again I have to come back, and therefore I'll have the stamp of a court or, authority in that. So this is what is the reality. So I'm not saying that, first and foremost is that we have to ensure by an amendment to the Act that there should be no ad hoc arbitration in India. Ad hoc arbitration is because whatever arbitration I have done in Singapore is all, institutional arbitration, and, many a times we don't have to go and see them or anything like that. You submit all the papers and, everything, whatever is the necessary fees, and, they prescribe a time limit, and after that, everything is to be given in writing, and after that, the order comes, and, we are there. So coming back to the banking industry is concerned, one thing is that why banks are not going into arbitration is concerned. So bank has two things, What happened is, I just recall the case of Booz Allen Hamilton versus SBI Housing Finance Limited, where, it's a 2011 case, but, wherein it has been completely written, whereas it has been elaborated, the guidelines are there, what is arbitrable and what is not arbitrable. So one is something, in the case of a bank is concerned, there are many other acts are concerned, the insolvency is there, the Surfacy Act is there, then the DRT Act is there. So though it doesn't override, arbitration doesn't override those acts or vice versa, or even though there is nothing mentioned in that, in those acts that, if such an act is there, so people go in for the other one because, that is much better, and, it is not something which is easy for the banks. Say arbitration is a private form, private thing. You don't have to go to the court and you do it there. Even if it is an arbitrable thing, then what happens is people use insolvency. Insolvency is concerned, and arbitration cannot do anything of that sort. So insolvency is now most successful. So even after insolvency is coming and most successful is IBC is coming, now the IBC feels that prior to bringing somebody into the IBC, there should be some kind of a pre-mediation where a restructuring or a outside the IBC, some kind of a settlement has to be there. A consultative paper will come very soon. I think they are asking for the views of it. So banks doesn't go, maybe in retail things banks do go, in the case of a vehicle or in the case of a housing, in the case of some goods or something like that, they may go. But otherwise what happens is that, banks does not go for this thing. The first case was HDFC Bank's case was there with Satyapal Singh. And, Delhi High Court upheld that if there is an arbitration clause, you have to go for arbitration. But that was overruled by the Durga Prasad's case Durga Prasad's case, where, it has been said that, what is arbitrable and what is not arbitrable. Everything which is not everything which you find is not arbitrable. So you have to understand that what is arbitrable and what is not going for arbitration. So unless and otherwise, as far as cross-border arbitration is concerned, the main thrust of India not being a hub of international arbitration. The morning session also we said that if foreign lawyers come here, India may become a good hub of arbitration. I doubt it, because of the fact is that unless otherwise, courts' interference in the award passed by the arbitral awards passed is limited or is completely curtailed to the extent, unless there is very specific reason for the courts to interfere, they don't trust here. They go to Singapore or they go to London or they go to other places, and even in some cases they go to UAE also. So that is where it stands. Banks per se is something which they want to create a jurisprudence, because I can arbitrate means, it is restructuring. Arbitration is nothing restructuring. They won't say. Arbitration is always there in the banking sector in another way, by settlement, OTS. OTS is nothing but arbitration, because OTS comes out and, when during the March period, every bank, when the NPA is there, they come out with some kind of a scheme called, this OTS is there. If you pay before 31st of March certain amount, and, if you pay it within 2 or 3 installments, it is there. And even under the SURFACE Act, ARCs, asset reconstruction companies also come for OTS, so RBI has come out with clear rules that there should be an independent board who will counsel, advisors who will go through it and recommend it to the board, and then the board can accept it, So in all these cases, arbitration in one form or another is always there. It is not arbitration, I would say mediation is always one form or another is there. So the arbitration cannot be taken as the complete source to wipe off all the litigation or all kinds of court cases which we face here. But the fact of the matter is that arbitration first has to be made institutional, and the less interference of the court has to be there. And if there is an institutional arbitration, 90% of the Section 11 petition will disappear, because it is an arbitration, has to go to an institution only. So this is where it stands.
Thank you so much for the very practical insights on the ADR aspects in the banking arena. I mean, that was like really helpful. So I think I will turn the next question back to you. Sorry, I think Aastha has to leave because she has another engagement. So quickly, Aastha will wrap up, and you can leave immediately once you've answered this question. So in the, again, interest of the audience, right, this is a very different question for you. So coming from an institution, institutions like you have your own education system, right, which is kind of evolved over a period of time. So how do you think this education system in particular could potentially impact the cross-border, ADR in the coming future? Because, they are very structured, and a lot of people are actually taking up these courses to enhance their skills and, kind of upgrade themselves, right? So from a practical point of view, again, I'd like you to quickly touch upon the impact, and also where do you think this is going?
Thank you very much, Smita, and my sincere apologies. But I think the most important question has been posed to me, which is the education. And we can talk about ad hoc arbitration and institutional arbitration and the conversion of ad hoc arbitrations into institutional arbitration, but that will not happen. And that I understand that you've mentioned that it must happen, and the legislature should make it so that all arbitrations should now be institutional arbitrations. As much as I would like that, I don't think that can be done.
It's a utopian thinking. And, I think, I'm just thinking, otherwise what happens is, it will never end. Otherwise it will never end, because these judges can be a part of the institutional arbitration, so they are bound by this thing. And, they have a standard fees, and, therefore, that will end the entire woes of arbitration, and people will take more into arbitration. Today what happens is, I suggest Dr. Rao's name, and, somebody will say, no, I want another lawyer, and then, both of us will go, and ultimately we'll get a third lawyer who may not be in the liking of both of us, and then we are left at the mercy of these two people. And then second thing is that, our Commercial Codes Act has a mediation compulsory, and that mediation is not a mandate, it is mandatory, but, if I don't appear there for 5 times also, there is no sanction or penalty imposed on me for not appearing. And next thing is that, it'll go as a suit. So that also has to change. Why for you're suggesting something, it is like, even if I don't appear for the KG class also, then I'll get promoted to 1, and then I'll go to 1 first. Why should I waste my time in going and studying in KG class, and I'll straight go to the first standard. That is where it stands. And third is that, definitely Dr. Rao will agree with me, is that, under some pretext or another, and the courts will interfere in any award given, either public policy or, that there was a fraud in it, there is some kind of anything and everything. It depends on the eloquence and, on the brilliance of and the face value of the senior lawyer appearing before the court. And, it get a stay, and then, the entire thing is gone. And, that is where it stands, And banking industry is concerned, we go for the IBC and SURFACE Act, because of the fact that, it gives a quick relief. And restructuring is there. That is what I said. Mediation is there, OTS is there. And OTS is restructuring, and OTS is nothing but a kind of mediation where, I restructure it. But even after restructuring, it doesn't come, and, then it happens to that.
I completely agree with you that institutional arbitration is need of the hour, and it will benefit only me if that is happening. However, arbitration is a process which the genesis of it is party autonomy. The courts cannot steal that away from the parties and tell them to go to an institution, because that goes against the ethos of arbitration. So, but I do understand the concern that is raised that when two parties are not agreeing on an arbitrator, it further lengthens the process, which is not the concept of arbitration. Arbitration, when it started, it had to be a speedy mechanism to resolve your disputes. Now, what has been done in Singapore to cater to that issue where two parties are not agreeing to an arbitrator, and let's say the arbitration is ad hoc, is that in the International Arbitration Act of Singapore, it is mentioned if two parties cannot agree on the arbitrator, then they have to go to SIAC, who will be the appointing authority. So they will not administer the dispute, they will not be the institution before which the dispute will go on, but they will only appoint the arbitrator for the parties. So this is another way we can look at for a speedy appointment process.
One thing is, I take that point from you. So what happens is, if not a complete ban, then you can fix some pecuniary limit, pecuniary limit. After that, it should have been an institutional arbitration. The other should not be an institutional arbitration.
Sorry, I think the question to you was on the education. So if
moving to the education bit. Now, the point I was trying to make, as long as we do not impart education, which is the most important, and that is the only way how we can convert ad hoc arbitrations to institutional arbitrations. For this, there are various organizations that are pushing education. One is CIR, Chartered Institute of Arbitrators, where arbitrators can get accredited. And once they have accreditation of CIR, institutions like us, of course, that's not the sole thing that we see in an arbitrator. Okay, the XYZ person is accredited by CIR, we can appoint him as an arbitrator. No, but it definitely helps us, because CIR is a internationally recognized organization which provides accreditation to arbitrators. So we will see that this person has an arbitrator's training. So this is another institution that we can go to and learn about arbitration, and they have several levels. They have fellowship, which is probably the highest level, which is if you are accredited as a fellow, you can write FCIR. And then there is member, which is probably the lowest level of accreditation, and juniors can go and take these trainings and be experienced in arbitration. However, I must point out it is not the case that if you go as a junior lawyer without any experience of having written an international arbitration award, accreditation will not help you. You need to have the experience. Institutions are very careful when appointing an arbitrator. So this is one institution. Second, the responsibility comes on us, the institutions. What are we doing? We are doing arbitrations day in and day out. What are we doing to impart the knowledge? So we have partnered with various law schools like NLU Delhi, Columbia Law School, Stockholm University has a partnership with Stockholm Chambers of Commerce. They run a very successful program, International Commercial Arbitration Law. It is only emphasized on commercial arbitration and how international processes function. I was very fortunate to take up that course, and there they teach you all the nuances on intricacies of international arbitration process. So that is something that we should be doing, and of course there is a cost involved in all these things, but I can say, because I've gone through it, the cost involved with Stockholm University is very low. It's nothing compared to the US universities. It's a fraction of it. Even 1/10 will be an exaggeration. It's less than 1/10 of it, probably 1/15 of it. So that's what we can look at, how to gain knowledge, how to impart knowledge. We do several training sessions. In fact, once we impanel an arbitrator on our panel, it's not the case that they will automatically start getting appointments as an arbitrator. That will not happen. What will happen is they have to go through a mandatory full-day training with AAA-ICDR, and then only their status as an arbitrator with ICDR will be activated. Once they have completed the training, only then they can be appointed as an arbitrator. So this is very necessary for us also to rely on them and to understand that, yes, now this person is capable of handling the disputes and writing down an award, because we are also very cautious about the awards that are published. If they are not enforceable, or if they are challenged, it's us who is responsible for it in the end. So yes, these are certain things that we are doing to impart knowledge. There are several conferences. As we speak, there is this conference going on, Delhi Arbitration Weekend, which is being hosted by the Supreme Court of India, the Delhi High Court, and the Delhi International Arbitration Center. It's a week-long conference where several students, young practitioners, senior practitioners, and judges, retired judges, currently sitting judges are also participating, and all they are talking about how we can make arbitration better. So this is another way to impart knowledge, and I think this is now happening more and more, although it becomes very difficult for me because having the region of entire Asia, I have to attend Hong Kong Arbitration Week, the Singapore Arbitration Week, but I think this is need of the hour and we need to impart more knowledge.
Absolutely. I think I can't agree more with you. So I think, the gist of it, what I understand is education definitely plays a vital role because, it enhances the quality of arbitration, of course. And also, on the other hand, institutions like yours and the arbitrators are both kind of interdependent, right? I mean, if one is not good, the other also is obviously impacted. So I think to strike the fine balance is what we're trying to do. And generally I think we will get there eventually. So with that, thank you so much, Aastha, for your time here, and I think it was really very nice to have you around, and certain key, I think, takeaways, which probably the audience also would agree with me. It was, the way you put across things, challenges, as well as the importance of education, I think it was lovely. Thank you so much for your time.
Thank you very much, Smita, for asking very topical questions.
Pleasure.
And thank you, Mr. Rao, and thank you, Mr. Balakrishnan. It was a pleasure to be on the same panel, and thank you for the lovely audience who was patient enough to go through my lengthy answers. Thank you very much. I'll take your leave now.
Sure. So, Mr. G.V. Rao, so I think I'd like to turn the next question over to you, sir. From what you have seen, do you think the ADR concept in India is like really mature? I mean, really up there, like its counterparts in the Commonwealth? If not, how do you think the Indian judiciary needs to gear up towards scaling up itself in terms of the ADR world? So that's the question to you, sir.
I'm associated with the Commonwealth. Recently I was attending the Commonwealth conference of lawyers in Goa, and also I was associated with the Commonwealth University, which is in London and in Benin. We are much better than about 70 or more percentage of the Commonwealth, which comprises of the Caribbean and some of the African countries and other places. So we are among the top in terms of that. I wouldn't like to have a somewhat dismal picture of what my good friend Balakrishnan has, but I would say that I refuse to look at things which are, in a way where you feel that they're not good enough, or of course, there's room for improvement for everything. But I wouldn't look at it as if it is the end of the road and there's nothing can happen to it. That's absolutely wrong. Yes, we as an ecosystem of legal fraternity, we need to pull up our socks. Right across the country, in every field, things are moving ahead. We are a great destination for foreign investment. Industry is moving ahead. Politically, we are seen as a country where great growth rate is there, and we are growing at about 6 to 7%, somewhere around that, which is one of the best in the world, and things like that. But yes, we have an archaic mindset. Our alternative dispute resolution mechanism is not as modern as it ought to be, is not as fast as it ought to be, is not as as effective and giving the necessary remedies. But we are getting there. It's not as if we are not getting there. I would say 3 years down the line, maybe in another 5 years down the line, especially, you see, I've done matters where clients from overseas really, I did many, about almost 2 decades ago, there was this company from Hong Kong which was investing in India call centers, and they were thinking that they should have the Hong Kong Center for Dispute Resolution. But, my Indian counterpart, my client, he said, look, it's so expensive for me to go there. I mean, why would I do that? No, the Indian court system is not so good. So we sort of came to an arrangement where we said, all right, we will do arbitration or, mediation or whatever possible to resolve the dispute amicably instead of going through the court system. And then they agreed to it. The Hong Kong investors agreed to it. So therefore, it's not as if, we are totally incapable of providing an effective alternative dispute resolution mechanism at all. That's absolutely not the way to look at it. That's not the way to think about it. Yes, we do have difficulties. When I find my friend criticizing the system, he says that, we need to improve. But it doesn't mean that there is no scope for improvement and that it will not improve. That is something that I wouldn't take it. And I see that the courts, I recently wrote an article about certain interference in a Singapore arbitration by an Indian court. And I was critical of the fact that they actually interfered in it. Because the whole purpose of going to institutional arbitration and to arbitration is that the court would not come back and interfere. Now today, Mediation Act latest, what it says is, if you enter into a mediation and it is settled, then it will be enforced unless it's been obtained by fraud or deception or any other kind of extra legal methods, and that's it. So even a mediation is now becoming enforceable under the latest act. Therefore, the courts are very, very proactive to ensure that arbitration remains arbitration, and it has less to do with the court interfering with it in a day-to-day manner. Otherwise, it's endless. There will be nothing. I mean, they are refraining from interfering in arbitration. They've restrained the temptation to go and interfere in it, the courts themselves. And they've understood the fact that the system cannot function if you were to go and interfere. On the contrary, they encourage mediation. They welcome arbitration. They refuse to interfere in arbitration. That is the trend. Now, exceptions don't make the rule. There are always exceptions. So we always tend to look at some exception and say, oh, court has interfered in some celebrity, in some case like the Singapore case, which prompted me, as one of those legal journals to ask me to write an article. And there also I said it isn't correct on the part of the court to interfere in that matter, in one very well-known family matter. So therefore, the thing is, I find that the court is becoming proactive. It is being, it is invited. One of the young ladies told about the conference that is being held or going to be held soon, where all of these people participate. The court, it's an enlightening process where the court itself finds not wanting to interfere in an arbitration procedure and give it a stamp of approval. Where it is fairly, the award is fairly. I myself was an arbitrator in one matter, which was the Delhi High Court referred to me, and I told the parties, you have one last chance to resolve this dispute in the next 10 years. If you listen to me, I'll do it. And the way to go about it is there should be a third method of alternative dispute, which is a combination of arbitration and mediation rolled into one, where you do give it some kind of formal character in terms of hearing, but the arbitrator is a little more proactive in ensuring that there is a mediated settlement. We will evolve, we can evolve. The fact of the matter is the courts have been burdened. There is a huge burden for results and remedies to be given, to relief to get, and at the same time arbitration is also evolving and mediation is also evolving. And the courts are conscious of the fact. It's not as if that, at the drop of a hat, they are willing to go and interfere in arbitration proceedings and, they are more and more conscious of the fact. So there is a general overall improvement. If you say, how much is the percentage of improvement? I would say 15 to 20%, 30%, good enough. I mean, where will you get an overnight 100% improvement in a system? But you cannot fail to make an effort. You cannot fail to look at it positively. You should make every effort that you can humanly possibly make to get the situation better. And to arrive at that, the same choices that you would have in choosing a doctor or a chartered accountant or any other activity or choosing a restaurant you want to go, you would like to do it to the best available. And you would like to find the methods of doing that, of advising somebody, and you will have to find people who are committed, who want to ensure. I mean, what a legal professional, by its very nature, must be the one who is the happiest when he finds his clients has found some relief, is finding a solution, is there to advance their cause. The system is functioning. There are people who are making tireless efforts towards it. And go ahead and do it. If it weren't that way, we wouldn't be where we are. I mean, it's not that, India is in the boondocks. No, sir, it is not. It is making, if it can be done in every other sphere, whether it be science, technology, electric vehicles, anything, name it. Why not in the legal arena? I'm sure it can be done. It's not as a hopeless situation. Some of the best and brilliant minds are in the legal fraternity, and it's only a question of commitment. It's a question of being, desiring to get there. It's a question of getting other people to do the same. And that's when we find results, and that is a thinking that is coming about among some of the leading professionals, and they want to do it, and they want to encourage others to do it. Because it's better to light a candle than to curse the darkness. It is better to prevent than to cure. You must similarly. I was at a conference just now on trade secrets and espionage, and I told them that all the legal professionals should advise their clientele first how to protect their proprietary rights, how to protect their intellectual property, and thereafter, if it fails, if you're taking enough protective measures, preventive, then you go ahead and use the legal processes and use it well. Apply yourself. Be encouraged to think the right, be encouraged to find the right people, be encouraged to, these sessions are for this kind of thing, where everybody tries to see how we can find solutions to things that they are. I, as a lawyer, was trained in a lawyer's office who never worried and spoke about a problem. He would only tell me, give me a solution, don't tell me what's the problem, I'm not interested. Tell me how do we solve this, tell me how do we get better to this. And that's the mindset that we should need, at least if the legal ecosystem is not functioning, is not as healthy as it ought to be. Thank you.
Thank you so much, sir. So I think...
Yeah, I think, I need to...
Quickly, because I think
quickly, it's 5 o'clock.
Bring the balloon.
What happens is, I think there is no perfect fit or perfect man, human being in this planet. Even Parampurush, Lord Rama was also, having some kind of accused of, leaving his wife, because of the hearing. Somebody told that she lived with Raman. So, my suggestions were that, the solutions to how to improve the existing system. My suggestions were that, I never said that, the arbitration or the ADR mechanism or the mediation in India is failing. My suggestion was only to how to improve it, So it's like, how a child is growing up, you give some more vitamin or, you give some more kind of, food. If somebody is bodybuilding and somebody takes some kind of to medicines to build up the muscles, and the muscles is needed, that is what I told. Because of the fact that, it's practically, we have seen in some cases, it's absolutely the Indian legal system, and the younger the judges are coming now, and, I can name many of the judges who are very wonderful judges in the sense, they are not the old school of judges who are well read, and who are aware of the artificial intelligence and, what is happening, who can vibe with younger generation. And, they are all very good judges are there, in the Indian system. I can't name them, because personally many of them are known to me, so I can name them that how good they are, and when we go there, we know what is happening. So today what happens is, I'm only saying is that, this system has to be improved, and the improvements only I have told. I have told is that the improvements which has to be there, there may be always some bad apple in the entire basket, and that bad apple cannot be equated and said the entire basket of apples are bad, that I agree. Because India has made tremendous progress, as far as India is concerned, the legal system is concerned. I'm not on the other things, that is not for anybody to say, because for the last few years it was very there. Overnight we changed into the system of hearing cases through online or, through VC. That I never imagined in my life that I'll be carrying a laptop and sitting somewhere and arguing the cases. And even today, now, except for the High Court, I prefer to sit in the comforts of my office and, attend the hearings wherever it is possible. So this is a tremendous thing, it's overnight, nobody, and many people said that, it's not correct, even in the official courts also now that is possible. So improvements is something which is needed, and every day you have to improve yourself, introspect and improve yourself, and then we will reach a goal. IBC came into existence, now how fundamental, and when you go there and when you say file a petition, it is settled. I don't want the company to be given to a IRP or an insolvency professional who come and take away entire thing. So improvement, saying that you can further improve, it's like a school teacher saying that you have the potential and therefore you have to improve. That should not be taken that the teacher doesn't like me. That is it.
Thank you so much. So I think we have, overshot the time, but it was a lovely panel indeed, and I think the wealth of experience each of them brought to the table was amazing. So thank you for being a wonderful audience. I'm not too sure if we have time for Q&A, but we can take it offline. So thank you.
Thank you so much for such a great presentation. It was a perfect showstopper of the day. Let's have a huge round of applause for all our panelists and keynote speakers here. Also, I would like to take this opportunity to thank Honorable Dr. G.V. Rao for his support throughout, and our association partner, the Indian Society of International Law. Thank you, sir, for your support throughout the conference.